Good afternoon, I'm Peter Bartinik, a board-certified civil trial attorney practicing law here in Connecticut. I'm just going to explain briefly what contributory negligence means and how it applies in a car accident case in Connecticut. And the reason I specify car accident case in Connecticut is because in other states, the rule is likely to be different than Connecticut. Some states probably have a similar rule, but each state has different rules, so you need to be aware of what state rule you're talking about. And in Connecticut, this is the general rule this applies to car accident cases and most negligence cases, but there are certain types of cases where this rule would not apply to. For example, a product liability case. First, let me tell you what contributory negligence means. This means when you bring a civil case against somebody, you are the plaintiff and the other side's the defendant. And the question in the civil case is generally going to be who's at fault and what are the damages. So on the question of who's at fault, in many instances, it's a disputed question, or it's a situation where both parties are partially at fault. All right? So contributory negligence is the negligence of the plaintiff. The plaintiff has contributed to the negligence, I guess. So it's contributory negligence. The rule in Connecticut is as long as the plaintiff is not greater than 50% at fault, they can prevail in the case and damages would be reduced by their proportional fault, because Connecticut has also adopted a comparative negligence rule. So that's the rule of contributory negligence in a car accident case, a civil car accident case in Connecticut. As long as the plaintiff is not over 50% at fault, then they can recover. I hope this helps you and is useful. Have a good afternoon. Bye-bye.